Welcome back, everybody. Happy Tuesday. Today, we're going to be talking about three lawsuits that are ongoing, and two of which I definitely know for sure have gained class action lawsuit status within the real estate industry. And this was brought up at the management issues event at GHAR that my uncle and I attended last week by Brett Woodburn, one of the real estate attorneys that was there. So we thought it was important to kind of fill everybody in on what's going on and how it pertains to us. And I'm going to do my best to summarize the the lawsuits that are ongoing. I'm going to preface this with I'm obviously not an attorney, but I'll do my best to fill you in and let you know what's going on. And then I'm going to give a couple points of recommendation as to what we should be focusing on within our business in regards to pertaining to these lawsuits. And then we'll open it up for discussion after that. So we'll jump in here and get started. So on March 29th, now I apologize for if I potentially butcher this name, the lawsuit Moehrl versus the National Association of Realtors was granted class action lawsuit status. U.S. District Judge Andrea Woods ruled that in addition to the 19 people that initially filed, thousands of sellers who have paid a commission between March 6, 2015 and December 31st, 2020, specified companies and MLSs, as well as current and future sellers engaged with those entities. So it's expanding to more people. This suit is seeking damages for sellers in the states Texas, Florida, New Jersey, Ohio, Pennsylvania, Virginia, North Carolina, and Colorado. The damages are tallying upwards of $13 billion. This recent ruling is particularly important because it pretty much guarantees that this is going to go to trial. The Moehrl suit names NAR, Rheology, Home Services of America, Remax, Keller Williams, and 20 MLSs, including Bright, as defendants. Additionally, there's a similar suit going on, Burnett versus the National Association of Realtors. This was filed in 2019 and gained class action status in April 2022. The difference between the two suits is that Burnett is limited to the state of Missouri. In general, the plaintiffs in both suits are accusing the defendants of conspiring to require home sellers to pay the broker representing the buyer of their homes and to pay an inflated amount, which is in violation of federal antitrust law. Additionally, there's yet another suit that was filed by REX, which, if you don't know of them or haven't heard, they're a technology company that claims to cut out the middleman, everyone except for themselves, obviously. But in any event, they use their technology platform in blockchain to allow sellers to transact directly with buyers. REX suit is against Zillow and accuses antitrust violations related to NAR's rule known as the no commingling rule. This rule prompted Zillow to separate non-MLS listings from MLS listings on their website, including listings from REX. REX argues that this rule and the testaments from the other two suits are being used to maintain artificially high real estate commissions. So all three of these cases, what does all this legal action mean to us? Obviously, the legal process takes forever and final court rulings are a very long way out. So I don't feel, in my opinion, that it's beneficial to spend a lot of time speculating how commissions will be paid out in the future if they are to change. However, commissions are under a microscope right now, with investigation coming from both the Department of Justice, and the Federal Trade Commission. Moral of the story. See what I did there?
Oh, that was a lawsuit. Very good.
All seriousness, we need to be professionals and do better. Okay, so what I mean is we need to clearly explain our contracts and agreements that we are having consumer sign and make sure they understand the costs and fee structures that are involved. They need to fully understand that the services being provided and why the listing and transaction process is structured the way it is. With all this in mind, I wrote down a few points that I think we should focus on in our business. First, we're going to talk about the listing contract. Are we thoroughly explaining the listing contract to our sellers, or are we simply just docu-signing it out there? Are you including an estimated net sheet with your listing presentation and explaining the costs? The fee should not be a revelation to the seller when you send them a proposed settlement sheet. They need to understand what they're paying for and what they're getting out of it. So I'm going to share my screen here real quick, and we're going to talk about the listing contract. So everyone should be able to see the listing contract. Give me a quick nod of the head if you can see my screen. So we're not going to go through line by line, but if you didn't know, RELRA, the Real Estate Licensing and Registration Act, requires some verbiage to be pre-printed in these contracts to kind of talk about this antitrust and competition that are involved in these lawsuits. So coming down to paragraph 2 here, no association of realtors has set or recommended the term of this contract. Broker/licensee and seller have discussed and agreed upon the terms of this contract. Again, this is in regards to competition. This means that it's a negotiated item. You know, none of the companies in the area or the Association of Realtors has conspired together and made a set term. Scooting down here to the broker fee. No Association of Realtors has set or recommended the broker fee. Broker and seller have negotiated that fee. The seller will pay the broker. So again, this is a product of competition in our market. We have to price, our services that are competitive against our market competitors. And it is a negotiation between broker and seller. We do want all this information to be filled out and accurate, obviously, but we're going to scoot down here to the second page. Cooperation with other brokers. Licensees have explained brokers' company policies about cooperating with other brokers. Broker and seller agree that the buyer or broker will pay a cooperating broker, whether that be a sub-agent or a buyer's agent. The purpose of all this, again, is you need to clearly explain these terms to the sellers. They need to understand what they're paying for and why it's set up that way. NAR has put together a lot of resources in these conversations you're having with your sellers that are useful. So I think it's competition.realtor. If you go to that using your URL bar, it's going to pull up their page. And part of that is this little infographic that kind of explains the economics of buying a home and why the real estate industry structured commissions the way they are. The current way broker services are paid out prevents a greater cost burden that would be especially devastating for first-time and low-income home buyers. If buyers had to pay real estate broker commission or compensation directly, it would add thousands of dollars to an already costly transaction. The typical American household has an average of $5,300 in the bank. That's a third of the median down payment on a starter home, which is around $16,000 or 7% of first-time home buyers. So the reason all this was set up that way is because the average Americans have most of their money not sitting in the bank, but tied up in equity in the house. And obviously, as sellers, you want to cast the largest net possible to attract the most amount of buyers, which obviously is going to result the highest price. And in doing so, if they pay out the commissions out of the equity of their home, it's more attractive to, like this infographic talks about, first-time home buyers and low-income home buyers. So again, all this is for you on NAR's website. It's competition.realtor, and I will disseminate all that information with the recap and everything when we're done with this. So the second point I wrote down is in regards to the buyer agency contract. I am gonna go back here, pull up the buyer agency contract, and we're gonna go through this as well. So again, we're not gonna go line by line, but I want to make sure everybody's thoroughly explaining the buyer agency contract to their buyers. And also, are you filling it out properly? Again, RELRA requires verbiage in here. Starting in paragraph 1, no association realtors has set or recommended the terms of this contract. Broker and licensee and buyer have discussed and agreed upon the length of the term of this contract. Broker may be paid a fee that is a percentage of the purchase price, even though broker fee or portion of it may be paid by seller or listing broker. Broker will continue to represent the interest of the buyer. Again, all this is a negotiation and a product of competition. Broker fee, no association of realtors has set or recommended the broker fee. Broker and buyer have negotiated the fee. Broker will receive for exercising professional knowledge and skills in locating and assisting buyer in acquisition of real property, which is available and suitable for the buyer. Very important. It's weird throughout our industry that because of the commission structure and the way they are paid out, a lot of buyer's agents tend to put zeros in this amount, which lies a lot of the problem in the result of these lawsuits. So when you fill out 0% of the purchase price in this area, and then on the settlement sheet, you're collecting money from the listing brokerage, that is a big no-no. That is a huge violation, and why you in fact have to put a percentage of the purchase price and your broker fee, if you collect one, in these agreements, not only for when a seller is represented by a real estate broker, but also for your protection if the seller is not represented by a real estate broker for sale by owner. So again, everybody needs to have a percentage in here, whatever your standard is, 2.5%, 3%, whatever you justify for the level of service that you provide, that information needs to accurately be filled out within this section. If you ever have any questions, obviously we're here to help. Give myself, Kong, my uncle, grandfather, any of us a call, and we'll walk you through it. So, my last point I wanted to bring up, it's also somewhat in regards to the buyer agency contract, and was brought up at the management issues event, and could be and constitute a antitrust violation if you have these conversations. Do not engage in the time-old buyer's agent disgruntled by the commission they receive on the settlement statement versus the listing agent. It's not appropriate after the fact to go to the listing agent and express that they should give you the same amount that they're receiving on their end. If you have those conversations, that needs to be upfront and before you ever put a contract in writing. If you're not feeling that 2.5%, 2%, whatever it might be in the MLS is not enough for your level of service, you either need to negotiate that upfront ahead of time with the listing agent or collect it from the buyer. You can't, after the fact, have a conversation with a listing agent or other brokerages and tell them that they need to be paying out the same level as what they're collecting. That, in fact, is price setting and a antitrust violation. So again, don't have those conversations after the fact, have them up front. Those are my 3 points that I wanted to bring up in my spiel for the day. I hope everyone isn't terribly, petrified, and, we can proceed with, concentrating on these items, but not be paralyzed in fear. So at this point, I'll open it up for discussion. Uncle Tim, Poppy, comments?
I think you did a good job explaining what we learned at the management issues breakfast. Again, I agree with you. I wouldn't spend too much time worrying about it as long as we're using the Pennsylvania Association of Realtors forms. We're filling in the blanks on the buyer agencies. We're explaining these forms and not just emailing them to them. We're docu-signing them to them. I think we're pretty well protected. I think, like you said, one of the most important things is to not have discussions after the fact about an agent who might have gotten 3% and paid out 2.5%. You can't have those type of discussions after the fact. The way that form is written on the buyer agency, if your form says 3% and the agent's paying 2.5%, you have the right to collect 0.5% from your buyer. If you decide not to do that, that's your decision. So as long as we're filling in these numbers, I wouldn't worry about it. Personally, I think a lot of these lawsuits are obviously about money with the attorneys more than disgruntled people. It's a way for them to make huge amounts of money. So, hopefully nobody's purposely practicing antitrust situations, but I think you did a good job in explaining it. Anybody have any questions about what Brooks proposed to us today?
Yeah, I have a quick question, Tim and Brooks. So it just, in looking at the buyer agency agreement, that the way that Brooks just explained it, it opened up a thought of mine. If I happen to put in that my minimum compensation is 2.5%, and then it works out that the house that we've sold is a 3% commission, is that an issue going to be a potential issue? I'm just curious. Maybe I'm overthinking it, but which I tend to do. But
yes, you do.
No, I think it specifically says in the agreement that you're willing to accept whatever the listing broker offers. Then it doesn't talk about it being more. It talks about it, if I remember correctly, being less. That in the event that it's less, you have the right to collect it. But I don't see it being an issue if it's more.
okay. All right, thanks.
Yeah, I agree with that.
Anybody else have any questions? Anything they'd like to bring up? Is Kong on the call? Kong, are you here?
So, I have a question about discussing the contract. So, and I'm not disagreeing, but I'm wondering to what extent we're allowed to interpret, because correct me if I'm wrong, doesn't it say somewhere on there that if they want legal advice, they should seek legal counsel? So, in going into in-depth explanation, are we crossing the bridge to giving them legal advice?
It's a good question. I don't think we're crossing the bridge if we're explaining or reading it to them. It is a plain language contract. Anytime we have a problem, typically one of the first things I always say to the agents are, did you read the contract? Or go back and read the contract. Because again, it is a very plain language contract. I don't think we're getting into it. If they have more questions than what the plain language contract says, then they might want to seek legal advice, but hopefully they can understand it just by reading the paragraph. It's not in legal terms that the average person gets confused by. It's, like I said, it's been written for us to be able to understand and fill in the blanks.
Yeah, I agree. I think all the problems result from simply quickly sending out the contract or not explaining any of it in any plain language form. People just either hand over the contract via email and have them print it out and sign, or they DocuSign it and don't explain any of the terms that are in it. I think it's our job to, in plain language, explain what's written in there, and make sure they understand what they're signing.
With regards to explaining the contract, it is very important that they understand what they're signing with regards to this buyer-broker agreement. In the last 2 years, we have had more problems with people who have made offers on homes and not gotten them, and then wanted to switch brokers, and they didn't realize that their previous broker had signed them to a 1-year contract. A 1 year. Now, there's certain brokers in our industry that if somebody came to you and said they wanted released, they didn't want to work with you, you would be fine and you would just release them. There's other brokers that would say, no, I want paid and I want a referral fee. Either way is okay. It's your business. You run it the way you want to run it. But what we're finding is that when agent number 2 goes ahead to work with a buyer and they get the buyer to fill out and sign the buyer broker form, the form is basically stating that they don't have an agency relationship with another broker, because most of these buyers don't realize that they're still under contract for the 6 months or a year. They thought that they were just under contract for the one transaction. So what I'm saying to our agents is, let's make sure we explain to the buyer how long they're under contract for. Whether you want them to be under contract for 1 day, 1 week, 1 transaction, or 1 year is entirely up to you. But if you're going to tie them to a year's contract, at least let them understand that if they, decide to go somewhere else, they're under contract with you, because that's where we're running into the problem. We've had at least 2 or 3 agents within the last 2 weeks that have started to work with a buyer, and then the agent number 1 has found out about it somehow. There's been different reasons why. One happened to be their lockbox was still on a house, that they also lost the listing had expired. And when our agent called to let them know that we were listing the home for sale and that they had already sold them a new home, the agent informed them that they were under buyer agency. So this is coming about more often. So please explain the length of the term to them. Brooks, Kong, want to add to any of that? Kong, I know you've been involved in helping a few of the agents with that situation.
I got a question.
Go ahead.
Do we have any kind of guideline as to things we can, or more importantly, cannot say that the broker fee encompasses?
There are no written guidelines on it. It's an additional commission. The
Right.
broker fee is an additional commission. It's part of the same services that you provide. Jim Goldsmith says that any agent can charge a different fee because there are certain agents that provide more services than other agents. There's some agents that have teams and have listing and closing coordinators to provide services that maybe a single agent doesn't have. So those are reasons why the fee might be higher than what somebody else charges. But it's not a fixed amount that has to be charged. You know, you're welcome to charge any amount that you want. Kong, are you back or are you still frozen?
Yeah, sorry
Okay.
about that. You just have to be really careful, especially with the scenarios that you had played out, Tim. If you're working with a buyer and they said, well, I've made several offers and can't seem to win, that's got to click in your head that, wait, they made an offer with another agent. Do they have a buyer agency? Right? So you got to get that and collect that information just to make sure that they're not under contract anymore. So it's just little telltale things like that. And most consumers these days, unfortunately, they don't know what they've signed. Things have gotten slipped in the DocuSign and .loop format, and these people don't know what they're signing. So just be careful with that, and be on the lookout for that type of conversation.
Seth, are you on the call?
Was.
Okay, there you
Yeah.
are.
Yes, sir.
So one of the other things that was brought up that we definitely want to make sure that we don't make an error and help back up our agents was selling property and not having, let's say, multiple parcel numbers on the property. So let's say that it includes parcel 1 and parcel 2. We've got to make sure that our contracts include both parcels. What was the example they gave us, Brooks? Do you remember what it was?
I don't remember specifically, but this is definitely a hot topic right now. Jim Goldsmith just brought that up in the legal comment column, the last article he wrote. You got to be very specific with these property descriptions and identification methods.
So we just want to make sure we're checking that we're selling the entire property and not missing a lot, that might have been included. We have one recently of something that was supposed to be excluded and it wasn't excluded. So we just want to make sure that, you're looking over those things. And Seth, when we're getting these buyer agency agreements and stuff, we've got to make sure that our agent has filled in a number on them. So as you're reviewing these contracts, we want to make sure that that happens. We were talking the other day, Kong, if we get an agent that has a escalation clause and they've chosen option number 2, we want to make sure that if you receive any sort of paperwork in our company, that the escalation clause has option number 2 listed, that you flag that and make sure we have a conversation with the agent and or Kong or Brooks, so that the buyer fully understands whether or not they're waiving their rights. Kong, do you want to explain that, waiving their rights again?
It's actually not the escalation clause, but the
Appraisal?
appraisal contingency addendum. So you have those two options that you pick, and everybody seems to always be confused as to which option your buyer should pick. But just putting it in real simple terms, option one allows the buyer to back out if the house doesn't appraise. And option 2 is a waiver. Okay, it means they don't care what it appraises for. So if there's a shortage in the appraisal, the addendum is null and void, and then you revert back to what you wrote in the mortgage contingency boxes of the agreement of sale. So if your buyer's intent is, and they say, I don't care what it appraises for, I'll cover the difference, then it's option 2. But if they want to back out because it doesn't appraise for a certain amount, okay, a certain amount, not the actual sales price, but it could be, a $15,000 coverage, $15,000 less, or it could even be $15,000 more than the sales price. Whatever amount they fill in, then they can back out with option one.
Years ago, when Poppy and I were in this business, there were legal descriptions in Perry County that talked about a property line being at the old oak tree, things like that. It doesn't hurt if you've got a really old deed and a lot of acreage to recommend to either the seller or the buyer to
Right.
have a survey done so that we can have an accurate legal description of what they own and know where their property corners are. So don't be scared of surveys. It's actually a good thing, and it will protect you in the long run. The other thing is when we're talking about parcel numbers and properties and surveys, we don't want to be pointing out property lines or property locations unless you are 100% sure, because there's a pin in the ground in that location. You won't find any builders that will do that, you know, either, because during construction, a lot of times the stakes are moved. So what you think is the property line might be 6 inches in the opposite direction. So again, surveys are very important. And, you know, pins in the property when it comes to what is owned and what is not owned, because it is becoming a problem with some of these properties.
Hey, Tim, I have some comments if you don't mind.
Yep.
So a few comments. Number one, back to the buyer's agency. And everybody knows this, but we don't have to recreate the form, meaning I see a lot of times where an agent might insert a broker fee in a separate line and they'll call it a transaction fee or call it something else. And we don't need to recreate the form or rename what our fee is. We just are simply plugging in what the agent's fee should be. So
Correct.
that's one comment that I see.
On the listing, you're right, Seth. On the listing agreement, it's called an additional commission. On the
Sure,
buyer agency, it's called a broker fee.
right.
But, you know, we
And I see a
cannot
lot of,
call it a transaction fee.
yeah, I see a lot of variation. Sometimes it's a Remax transaction fee. It's whatever it is. We don't need to rename it. We just need
Just
to
fill in the blank.
just fill in the blank, right? So that's one comment. Back to the parcel numbers. If we're selling multiple PINs, parcel identification numbers, what usually happens is the title company will notify me stating, "Hey, Seth, did you know that 555 Main Street really has an additional PIN or parcel number?" So at that time, I'm creating an addendum for the agents or the sale. But yeah, we got to be specific on what we're really selling. If we're selling 555 Main Street and maybe 554 Main Street or an additional lot, but a lot of times those blanks are omitted and they're there for, or, you know, a reason. The more information that is inserted is a better practice.
And I agree. And we're getting paid a lot of money to sell these properties. It's just a little more due diligence, you know,
Right.
whether you're on Bright MLS or Cumberland County's tax mapper or Dauphin County's tax mapper, Perry County's or whatever. Just make sure you're clicking on these things to make sure what they own and what they're selling. Maybe they're not selling that extra lot on the side,
Sure.
but maybe they are. So, you know, do your due diligence, ask enough questions, and let's do the job right. Anything else, Brooks, Kong, Gene?
The only other comment that I would have is under the buyer agency, and you've explained to them that it needs to be filled out. Do not apologize for your worth. You know, whatever your number is that you decide to put in there, That's a good number. You're going to give them a service for that number. If it so happens that the seller is willing to pay the buyer's commission, that's fine, but also explain to them that they may have to come up with additional money. Don't be afraid of that. It's okay. It's part of the contract. And it's up to you whether you want to negotiate it or not, but up front, you've got to be within the law. And that allows you to be within the law when you fill it out that way.
And you're right, Dad, because there are some brokers and agencies out there that are offering 1.5%, 2% to the buyer agent. And if that's not enough, you have to just, your buyer has already signed a document that says that they will pay you 2.5 or 3%. If, you know, so you just have to explain it to them, and it's a simple charge, that you don't work for any amount other than blank, whatever your amount is.
They'll come
Don't
up
be
with the
afraid to
money
do
if they want the house bid enough.
Right, yeah. Anybody else have any questions that they'd like to talk about? Kong, when's the next training session?
Tomorrow at 2:30, we're going to talk about past clients and centers of influence. And then Thursday, we have training. It's going to be on the mortgage contingency portion of the contract, actually.
Okay,
Yep. So Thursday at 2, Wednesday at 2:30.
so in the mortgage contingency, are we going to talk about, you know, the soft, what we call appraisal contingency that's involved in that?
Yeah, we're going to talk about pretty much going through the whole portion there, loan to value, the mortgage commitment date, stuff like that. Just things that we seem to still see that's a problem when we receive a offer from buyer agent.
So if you don't 100% understand how these mortgage contingencies work, then again, you said that's Thursday at what, 2:30?
2 o'clock
2
Thursday.
o'clock. And Wednesdays it is at 2:30 tomorrow.
Correct.
Correct. So Wednesday at 2:30 is one training session. Thursday at 2 o'clock is the other one.
And
So-
just a quick comment there, when you're talking about past clients and centers of influence, historically, that represents about 65% of, or up to 80% of somebody's business that has been in this business over 5 years. Please take care of those people by having a database that allows you to be able to contact them with a snap of a finger. It's very important that you have that information in hand, and this new KV Core apparently allows you to do that.
Yep. The last thing is this morning at 8:15, Keith LaPrairie, Kathy, Connor Anderson, and myself got into the conference room and role played. Thank you for those that attended. In the event that you want to do any role playing, I think they're doing that Tuesdays and Thursdays at 8:15. If you're not available for role playing and you'd like to role play at all, we can also set up some Zoom calls to do that. I know Brooks is getting ready to do another dialing for dollars here soon. That we're going to get that on the agenda, and we have.
Yeah, I wanted to plug that. That one's next Tuesday. Guy is gonna be there as well. And again, that's Tuesday, May 2nd from 5 to 6. So we're excited to do another one of those.
We're throwing a lot at you. We're just trying to be there for you. If you need us, call us, text us, email us, whatever it is, the communication that you use. And Brooks, Kong, Gene, everybody, good job. And we'll see you next week.